Hi, this is Tony Mike Gravel coming to you from Chicago. As usual, I've got another fun one. This is out of Washington. It's a new judge, Judge Bartlett. It just came across my feed, and I had a little hard time classifying this one. I'm going to call it a pro se fail, although that's not quite right. She is represented, but she talks her attorney into letting her say her piece at this hearing, and it does not go well. Other contenders were DUI, because it is a DUI, and also she arguably is a Karen. Let's do it.
Copy of the plea bargain that Mr. Schultz with the city was referring to. You just want to have a seat and take a look at that. Okay, and in the meantime, we'll call Christina Dawson. Miss Dawson, can you please unmute yourself?
There.
Good morning, and for the record, can you again tell me your name?
Yeah, Christina Dawson.
Thank you. And Ms. Dawson, you're here for your mandatory pretrial hearing. I have your attorney, Mr. Pasco, present as well. Go ahead, Mr. Pasco.
Thank you, Your Honor. Ms. Dawson has informed me that she would like to make 3 statements related to this case procedurally. I offered to make them. She'd prefer to make them. I'm okay with her making them as long as she doesn't talk about the night of the incident. And then when she's finished making those statements, it's my anticipation we just ask to set the case for trial.
Translation: I think this is a horrible idea, but she paid me, and I tried to at least explain to her what she can and can't say. Let's see what happens.
Okay. All right. Go ahead, Ms. Dawson. I just want to caution you, we are being recorded in court. So like your attorney said, please don't say anything about the facts of the case. Even if it's something you think could help you, it could be used against you in the future. With that said, go ahead.
Yeah, and again, this is something, whether, it's me that says it or him, I'm perfectly fine with, but speaking with another attorney and also somebody who is a good friend of mine that is a retired police officer, some information that I've had to do most of all my research myself, it seems. And one of the things in general was the report, the toxicology report. One piece that, again, that doesn't have to be necessarily a trial, but I can tell you now, is that when the so-called evidence, these blood tubes were received by the Washington State Patrol Toxicology Lab, they made a note here. It says, observe the following, sample unlabeled. So that's concerning. A friend of mine who is a retired officer had said, that right there, the case should have been thrown out. The second piece is these labs were drawn, and I know the lady had at the hospital, I worked at Peace Health for 15 years, I'm a nurse, she handed me the tubes, had me confirm that it was my name, date,
I mean, look at this. Look at the expression on her attorney's face. He's absolutely in pain. She's doing exactly what the judge admonished her not to do, which is going straight to the facts of the case. This is a horrible idea on every front. But we're hoping the attorney's just hoping it'll be short, and so is the judge. But she goes on. Hi, this is Frankie with the Sovereign Citizen Patrol, and I'd like to remind you to please hit like and subscribe, or I'll be personally offended.
The information was correct on those tubes, and then handed them back, and I signed something, and then she gave them to a police officer. So again, I know my tubes had my sticker on them. They were then placed in a locker, supposedly per the officer, for 11 days. And then,
Ms. Dawson, I'm just gonna pause you for a moment there.
Sure.
It sounds like you're bringing up some evidentiary concerns. I don't know if you're ultimately requesting for certain evidence to be excluded or suppressed, or if you're challenging whether the case should be dismissed. But if you're doing any of these things, you still have an attorney representing you, and your attorney would actually need to file proper motions before the court. There's no action that this court could take today on any kind of motion to suppress evidence or exclude evidence or any kind of motion to dismiss. So there needs to be something formally in writing submitted to the court, and then we need to set that for a separate hearing.
Well, he admitted
that is just spot on from the judge. Of course, she knows what she's doing. She was very patient with it, and then just saying, look, you're basically making an oral motion to suppress, and that's not how we do things around here. This woman does not understand what that is, as you'll see. She carries on. But this is just not a good idea at all. There might be some good reasons to file a motion to suppress, and the basis for it might be okay. But now is not when you bring it up. Nothing good can happen, and a lot bad can happen.
mentioned that he spoke to the prosecuting attorney and that they were going to
Christina,
Just set this for trial, please, Your Honor.
Okay.
All
Well,
right.
I was told
That is the prosecutor barges in with, can we just set this for trial, is actually being nice. What he's saying is, I can see this defendant destroying herself. Can we just cut this off and set it for trial? He's just trying to help move it along. Everybody here understands this except the defendant.
that if you knew this evidence, that you could possibly get this thrown out just on the 3 things that I had.
I suggest you speak with your attorney.
Yeah, it's not anything that we could address today. The limited thing you're here for today is called a mandatory pretrial hearing. And so at this hearing, we'd either be setting your case for a change of plea or we'd be setting it for trial. Again, if you're trying to suppress or exclude evidence or trying to have the case dismissed, that's a formal written motion that would need to be submitted to the court, and we'd set a hearing for that. Because
I'm not trying to suppress anything.
Because you have an attorney representing you, those motions would be filed through your attorney.
Right there, she says, I'm not trying to suppress anything. It's exactly what you're trying to do, and that's the right thing to do. But you don't even realize it. If your attorney's aware of these things, if those arguments have merit, he will file a motion to suppress. If you're making an argument that they can't have a chain of custody on their main evidence. If you get that evidence suppressed, the state can't meet their burden. Then you move to dismiss. That is the process of what is going on. And the judge even says it to her. And then, of course, she argues with the judge. She knows better than the judge as to what she's doing. Oh, Lord.
But
Can he mention these 3 things?
The court do today. Pardon me?
Can he mention these 3 things? Because I asked him yesterday if he was.
So if your attorney is representing you, it's going to be his decision what motions are brought to the court's attention. But I can't address any of these issues today at your mandatory pretrial hearing. So I'd encourage you to get in touch with Mr. Pasco about how to approach these procedurally.
Okay.
The answer is yes, he can mention these things. And if they have merit, he will mention these things. But today is not the time or place for it.
Okay, and then we're going to go ahead with setting the case for trial today. Let's see, because of the excluded time period for COVID, today is our speedy trial commencement date. That means we'd need to set for trial by June 22nd. Mr. Pasco, we have trial dates at the end of May or beginning of June. So either May 26th, excuse me, wait. Get my correct calendar. Either May 26th or 27th. The 26th is a Thursday, or June 2nd or 3rd. So our Friday dates are May 27th or June 3rd. Any preference?
Either's fine with myself.
Pardon me?
Either one is fine with me.
Okay. How about Mr. Schultz with the city? Any preference?
What date was it again, Your Honor?
Either the Fridays are either May 27th or June 3rd.
Do we have any 2-day consecutive period of time?
It's always going to be a Thursday and a Friday. So there's also May 26th or June 2nd, but our trial dates are Thursdays and Fridays now.
Judge, can I say something?
No, not right now, just a moment.
Okay. Sure.
Let's take the 2nd in time then. What was that?
June 2nd?
That'll work.
Okay. Ms. Dawson, are you available for trial on June 2nd?
I am, but like I mentioned, I'm not trying to exclude anything. But one of the other things was the blood draw was done 3 hours after I was taken, more than 3 hours after I was taken in. I would have been told it should have been done 2 hours. But then
this just shows she didn't understand anything that just happened prior, and she's carrying on with the same stuff. Your case just got set for trial. Okay, if you want to exclude evidence, you need to file a motion. If you want to file a motion to dismiss, you file that. Again, there's not something where you just show up like Perry Mason and drop a couple truth bombs on and the judge dismisses your case. That's not what's happening today.
2 hours.
Oh.
So there's just these extenuating circumstances.
I understand that, but what extenuating circumstances mean for the purpose of a criminal case is you're either trying to get evidence excluded or you're trying to be included. Okay. If so you can talk to your attorney about what evidence you're trying to get included, but if you're trying to exclude evidence or trying to dismiss a case, those all need to be written motions filed with the court and set for a separate hearing.
Okay. And do they need to be a full hearing with a trial or just like what we're having now?
That's what you can talk to your attorney about, but nothing
Okay.
can happen until a written motion is filed and we actually set for a hearing.
Okay.
Okay? All right, so I'm about to give you some future court dates. Give me
Okay.
just a moment. So Mr. Pasco and Mr. Schultz, if you wanted the readiness to come before this court, we would do it on May 5th. Otherwise, we can do the readiness before a different judicial officer a couple weeks before the trial. Do either?
I
of you
like
have
the
a
May
preference?
5th concept, Your Honor. That ought to give us plenty of time to have all the witness interviews completed, complete any of the necessary hearings from the sounds of it, and then be ready to proceed to trial on the 2nd.
All right. Is that okay with you, Mr. Pasco, May 5th for readiness?
Yeah, that's fine. Thank you, Your Honor.
All right, thank you. Okay, so Ms. Dawson, your two future court dates will be a readiness hearing on May 5th at 8:30 a.m. And then trial is being set for June 2nd at 8:30 a.m. Those are both mandatory court dates, May 5th and June 2nd. June 22nd is our speedy trial deadline. Okay, Mr. Pasco, anything else from you?
Nothing at this time. Thank you, Your Honor.
Mr. Schultz?
Nothing, Your Honor.
All right, Ms. Dawson, any questions about the court dates that were set?
No, no questions.
All right, so please get in touch with your attorney about all of your other questions so that he can address anything with the court that he deems appropriate. That's going to conclude your hearing for today. Thank you.
All right, thank you.
Well, there you have it. Effectively a pro se who's represented. The likely outcome here, I would say statistically, so I don't know the underlying facts in this case, is that this case resolves via plea bargain long before we do anything. If there are problems with the sample or something like that, then your attorney has more leverage on that. If that process is failing, then he's going to file motions to suppress. If all that makes sense, I don't know any of the other facts. Maybe they can prove this DUI up completely by body cam and field sobriety tests and all sorts of other stuff. So I don't know any of that stuff, but it is a horrible idea to spitball defenses that you're not familiar with at the pretrial with the prosecutor there. It's not helpful. Here at Law Talk, we like to have fun with silly stuff that happens in court, and every once in a while, and completely by accident, I assure you, you might learn something. Thanks for watching.